Hello, I'm Attorney Todd Leneve. Welcome to Casual Friday on West Virginia Gun Law. This week I was asked a question by a U.S. Law Shield member about having a medical cannabis card and applying for a West Virginia concealed handgun license. And I thought we'd take a minute and talk about that today. Stick around. So marijuana rescheduling has been in the news here recently. In fact, I did a video on it a few weeks ago. And that is the result of the Drug Enforcement Administration determining that it wants to reschedule or reclassify marijuana from a Schedule I narcotic to a Schedule III drug. The difference there being Schedule I narcotics currently are drugs that have no recognized medical purpose and have a high risk associated with their use, according to the DEA. Now, under Schedule III, marijuana would then become a valid medical drug, something that does have a recognized medical use and carries a lower risk of use associated with extended use or prolonged use of that particular drug. And so, under Schedule III, marijuana would be able to be used federally as a prescription medication. Now, some states currently have changed the way they approach marijuana, and here in West Virginia, for example, we have legalized medicinal cannabis, medical cannabis, and that is cannabis used in a variety of forms under the prescription and direction of a medical doctor who makes sure that you meet the various criteria for issuance of a state medical marijuana card. And if you do meet those criteria, you can get that card, and then you may lawfully use medical cannabis consistent with the terms of that prescription. Some states have even gone so far as to legalize it recreationally, meaning you can just smoke for the heck of it, and if that's your thing, you're allowed to do it there. We don't have that here in West Virginia yet, but the key here, folks, is to understand that federally, because marijuana remains a Schedule I drug, there is no recognized legal valid use of marijuana at the federal level. So where does that come into play here with this issue about obtaining a concealed handgun license? So under various state laws that govern the issuance of a concealed handgun license or a concealed weapon permit, whatever your state may call it, there will be a set of standards that you have to meet in order to prove that you are eligible to obtain that license. And so under West Virginia's law, for example, we have some specific guidance with respect to the use of alcohol and drugs in considering whether or not a person is in fact eligible to obtain a concealed handgun license. Let's take a look at that statute now. One of the characteristics required is that the applicant is not addicted to alcohol, a controlled substance, or a drug, and is not an unlawful user thereof, as evidenced by either of the following within the 3 years immediately prior to the application. A. Residential or court-ordered treatment for alcoholism or alcohol detoxification or drug treatment, or B. 2 or more convictions for driving while under the influence or impaired. So what this law tells us is that if you, in West Virginia, have a medical cannabis card, as long as you are using cannabis consistent with the prescription as defined on that card, you're not an unlawful user. Proving addiction falls under one of those subsections that we just looked at, and it's incumbent on the sheriff to make a determination based on a background check to see if there is anything in your background that would suggest addiction is an issue. But merely having a medical cannabis card does not imply addiction, nor does it imply unlawful use. Now, that being the case, you should be eligible to get a West Virginia concealed handgun license, even if you have a medical cannabis card. But then we're reminded of the federal standard which is set forth in the Form 4473 regarding unlawful drug use and possession of a firearm. Now, the 4473, of course, is the form that you have to complete when you go to a firearms dealer to purchase a gun. And there is a specific question on this topic. Let's take a look at that. Question 21E asks the applicant if they are an unlawful user of or addicted to marijuana or other drugs, and then goes on to clarify the question in a special note that reads, "Warning, the use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized for medicinal or recreational purposes in the state where you reside." So even though you may be able to get a state-issued concealed weapons permit or license, and even though your state may legalize marijuana for some particular use, this question on the 4473 is a stark reminder that the federal government doesn't go this direction just yet. And so what that means is that you can't lawfully purchase a firearm, even if you are defined as a lawful marijuana user under your state's laws, because federally you are still considered to be an unlawful user. As it says, they don't care what your state's laws may be with respect to legalization, decriminalization, they don't recognize it. And so as a result, even though you can get that state concealed handgun license, concealed weapons permit, whatever you call it, you still can't federally possess a firearm. You technically are a prohibited person. So what about folks that may have the temptation to answer that form in the negative and say, well, I'm not an unlawful user. In my mind, I believe that I'm doing this lawfully and the government can't tell me otherwise. Well, you can go ahead and do that, but it's not a sound strategy because you've just falsified a federal form. And if you do that, you are probably going to end up like this guy, who is the last person I think most of us want to be like, especially when you consider the fact that most of us aren't going to be able to get a presidential pardon from daddy. So don't take the chance of saying, hey, I'm going to gamble with this because my state says I'm a lawful user. You're not a lawful user as far as the federal government is concerned. So that's why this whole issue on rescheduling from Schedule 1 to Schedule 3 is a really important issue for members of our 2A community who do use marijuana in a medical basis. This will pave the way for you to be able to lawfully possess firearms, because now with that rescheduling, if it occurs, you would not be seen as an unlawful user. I appreciate you spending a few minutes with me here today. If you haven't subscribed yet, please do so. We'd love to have you as a part of our community. Hit that like button, share this video. I will see you the next time around, and until then, take care and be safe.